committee will come to order. Senator Murkowski and I want to welcome our witnesses. And this morning, the committee is going to hear testimony on the results of last November's vote on Puerto Rico's political status and on the President's response. Puerto Rico has been a, quote, unincorporated territory of the United States since the conclusion of the Spanish-American War 115 years ago. After 115 years, it is clearly time for Puerto Rico to determine what political path it will take. The question of whether Puerto Rico should become a state or a sovereign nation, and whether there are other options, defines much of the political debate today on the islands. Puerto Rico faces huge economic and social challenges. Per capita income is stuck at about half that of the poorest U.S. state, and the violent crime rate is well above the national average and rising. The lack of resolution of Puerto Rico's status not only distracts from addressing these and other issues, it contributes to them. As the most recent report from the President's Task Force on Puerto Rico's status found, and I quote, identifying the most effective means of assisting the Puerto Rican economy depends on resolving the ultimate question of status. 95 years after receiving U.S. citizenship, Puerto Ricans have achieved leadership in the U.S. military, in business, in the Congress, on the Supreme Court, and in many other prestigious positions. But for Puerto Rico to meet its economic and social challenges and to achieve its full potential, this debate over status needs to be settled. Puerto Rico must either exercise full self-government as a sovereign nation or achieve equality among the states of the Union. The current relationship undermines our country's moral standing in the world. For a nation founded on the principles of democracy and the consent of the governed, how much longer can America allow a condition to persist in which nearly 4 million U.S. citizens do not have a vote in the government that makes the national laws which affect their daily lives? That is the question. Today, the committee will hear testimony about the most recent effort to resolve the status question, last November's vote. I expect to hear two vastly different views about what the results of the vote mean. However, there is no disputing that a majority of the voters in Puerto Rico, 54%, have clearly expressed their opposition to continuing the current territorial status. Given that fact, I agree with the President's proposal to resolve this dispute through a federally sponsored referendum. I also agree that the ballot questions should be reviewed by the Department of Justice to ensure that the options are not inconsistent with the Constitution, laws, and policies of our country. The Justice Department review is essential to ensuring that the proposed new Commonwealth status or a proposal with similar features will not be on the ballot. The new Commonwealth option continues to be advocated as a viable option by some. It is not. Persistence in supporting this option after it has been rejected is inconsistent with the U.S. Constitution, by the U.S. Justice Department, by the bipartisan leadership of this committee, by the House, and by the Clinton, Bush, and Obama administrations, undermines resolution of Puerto Rico's status question. The rejection of the current territory status last November leaves Puerto Rico with only two options: statehood under U.S. sovereignty or some form of separate national sovereignty. The federally sponsored vote should be simple and straightforward and reflect these two choices. Today, we will hear from the presidents of Puerto Rico's three principal political parties: Governor Padilla of the Commonwealth Party, Resident Commissioner Pierluisi of the State Department, and former Senator Berríos of the Independence Party. The full written statements of all our witnesses will be entered into the record. I'm going to ask each of you to summarize your oral remarks to not more than 5 minutes, but let us first have the opportunity for Senator Murkowski to make her opening remarks.
Thank you, Mr. Chairman. Good morning, and to our distinguished panelists, welcome to the committee. Mr. Chairman, as you noted, this hearing is a direct result of the November 2012 plebiscite that was held in Puerto Rico on their political status. It's an issue that I have taken an interest in and perhaps feel a sense of kinship, as I believe I'm the only sitting United States senator who was actually born in a territory. So that dates me a little bit, but I'm okay with birthdays. It's better than the alternative. It's long been my position that the process for determining Puerto Rico's preferred political status should come from Puerto Rico and not from Washington, D.C., just as the residents of Alaska and Hawaii did as the last two states that were admitted to the Union. Now that the plebiscite has been held, it's clear to me that a majority of Puerto Ricans do not favor the current territorial status as evidenced by the first question on the ballot. The result of the second question, however, is not as clear to me, nor is it certain that any of the valid status options would receive a majority vote. And when I use the term valid status options, I'm referring to the continuation of the current Commonwealth status, statehood, independence, and free association, similar to what the United States has with the Marshall Islands, Micronesia, and Palau. Back in 2010, I joined with our former chairman, Senator Bingaman, in outlining these options to the President as the only four status options available for Puerto Rico's future relations with the United States. It was my preference leading up to the November 2012 plebiscite that the ballot have one question with each of the four options listed. Puerto Rican government, however, chose to go with the two-question ballot, and as a supporter of the process being driven by Puerto Rico, I respect that decision. But what we learned is that the current status does not have majority support. Beyond that, I don't believe that we can draw any definitive conclusions about the plebiscite results. The President's FY14 budget request included $2.5 million for another plebiscite in Puerto Rico. But even if a new plebiscite is held, it is the Puerto Rican legislature that will determine how that ballot will appear. And if that path is chosen, I would encourage a format that is fair to all valid options. I look forward to hearing from the representatives that we have here this morning. Again, a very distinguished panel on a very important issue to the people of Puerto Rico.
Thank you very much, Senator Murkowski. Let us begin with the Governor, Governor Padilla. Then let's hear from the resident commissioner, Pierluisi, and Senator Berríos will then proceed. So, Governor, welcome, and we'll make your prepared remarks a part of the hearing record in their entirety. And please proceed, if you would, for maybe 5 minutes or so. I think you'll get questions from senators.
Thank you, Mr. Chairman, Ranking Member Murkowski, and member of the committee. The stated purpose of this hearing is to receive testimony on the status referendum that took place in Puerto Rico this past November and the administration's response. As governor, I would prefer to testify on measures to create jobs or fighting crime or energy, which is so important for Puerto Rico and the agenda of this committee. The people of Puerto Rico feels the same way. However, I welcome this opportunity to set the record straight. The 2012 status referendum was crafted by the statehood party, then in power in Puerto Rico, to force an artificial majority for statehood. The process they choose, excluding Commonwealth from the ballot, is the same suggested by the delegate Pierluisi 4 years ago. Commonwealth wasn't there. That process was swiftly rejected in the House and the Senate because it's disenfranchised. I repeat, disenfranchised a majority of the voters. When the bill came to the Senate, Delegate Pierluisi told this very same committee regarding the second vote, and I quote, "Let's make sure that's nobody left out, nobody who wants to support the valid option. And the current statute call it the Commonwealth is one option," end of quote. His running mate, former Governor Fortuño, was more emphatic. I quote, "The current statute will stand equally alongside the other possible status alternatives," end of quote. Those democratic values stated in this room were not repeated in Puerto Rico. Out of Congress side, they legislated to exclude the Commonwealth. Nevertheless, you can see through the numbers. Almost 1.9 million voters participated, and little more than 800,000 voted for statehood. Statehood rallied 44.4%. Blank ballots, 26.5%. What they call sovereign Commonwealth, 24.3%, and independence, 4%. This is the takeaway. Statehood received only 44.4% of the ballots cast. Because of the way in which the plebiscite was structured, many of us asked the populares to cast the ballots blank. Other leaders in my party asked that they vote for sovereign Commonwealth. Combined ballots cast for sovereign Commonwealth and blank ballots were a majority of the votes. The White House Task Force report has warned that removing the Commonwealth option from the ballot, and I quote, would raise real question about the vote legitimacy, end of quote. And such warning proved to be correct. To set the record straight, the Puerto Rico legislature adopted current Resolution 24, which I'm pleased to submit with my statement. History, Mr. Chairman, has taught that only consensus-driven process will succeed in Washington. We welcome the administration's request for a new vote, and we look forward to working with the Department of Justice to ensure a process that is fair, transparent, and democratic. I commend President Obama for proposing a new plebiscite with fairness to all status options. I also thank the White House for working closely with us on the key issues affecting Puerto Rico: fighting crime, energy, health, education, jobs. I respectfully urge the Senate to follow President Obama's recommendation. What Puerto Ricans want is a true self-determination process, not political games. What happened in November was a political game. This, Mr. Chairman, is the way to go. As governor, I defend the right of pro-statehooders, pro-independence, and pro-Commonwealthers to have their option in the ballot. That's the way to go.
Governor, thank you very much. Let's go next to the resident commissioner, Pierluisi. Mr. Pierluisi, and Commissioner, please proceed.
Chairman Wyden, Ranking Member Murkowski, Senator Heinrich, Senator Flake, I am particularly pleased to see my former colleagues here serving in the Senate. And I'm glad to address the committee on this so important issue. Last November, Puerto Rico held a free and fair vote on its political status. The ballot had two questions. Voters were first asked if they want Puerto Rico to remain a territory. 54% said no, and 46% said yes. I have the official certification of the State Elections Commission of Puerto Rico to confirm this. A party in Puerto Rico, the PDP, urged a yes vote. Nevertheless, voters rejected territory status by a wide margin. The current status has now lost its democratic legitimacy to the extent that the people of Puerto Rico ever consented to this status. Such consent has been withdrawn. This result should not be surprising. I represent more U.S. citizens than 42 senators. My constituents have fought side by side with your constituents from Korea to Afghanistan. They can move to the States for the price of a plane ticket. But if they stay in Puerto Rico, they cannot vote for president, have no representation in the Senate, and elect one member to the House. I can only watch as my colleagues cast floor votes on bills affecting every aspect of life on the island. I depend on the goodwill of senators elected to protect the interests of their constituents, not mine. I request assistance from a president who's not required to earn a vote in Puerto Rico, to expect a presidential administration to feel the same obligation to support Puerto Rico as it does the states is to substitute hope for experience. The failure of the current administration to send the witness to testify today is a sad reminder of this point. Moreover, territory status gives the federal government license to discriminate against Puerto Rico, and the island is treated unfairly under numerous federal laws, including most safety net programs. There is consensus that territory status is the root cause of the economic problems that have persisted in Puerto Rico for at least 4 decades. The best evidence that the status quo has failed is this. In the brief period from 2004 to 2012, Puerto Rico's population decreased by 4.2%, with hundreds of thousands of residents leaving for the states in search of improved quality of life. I turn now to the second question in the referendum, which asked voters to express their preference among the 3 valid alternatives to the current status. Of those who chose an option, 61% voted for statehood. The State Elections Commission so certifies as well. And for the first time ever, this is important, for the first time ever, the number of votes for statehood exceeded the number of votes for the current status. Before the vote, the PDP claimed that the second question was unfair because it did not include its status proposal, known as Enhanced Commonwealth. Party leaders urged voters to leave the question blank, and some did. They now cite this abstention as the basis for their argument that statehood somehow lost the vote. That is nonsense. Self-determination is a choice among options that can be implemented, not an exercise in wishful thinking. The PDP's proposal has been repeatedly rejected by federal officials, including this committee, on legal and policy grounds. Therefore, it could not have appeared on the ballot. Ultimately, those blank ballots do nothing to detract from the main point, which is that a majority of voters reject territory status, a supermajority favors statehood among the alternatives, and more voters want statehood than any other status option. No senator would accept territory status for their constituents, so you must respect that my constituents do not accept it either. With my support, the administration requested an appropriation to conduct the first federally authorized status vote in the territory's history, with the declared goal of resolving the issue. That funding was approved by the House Appropriations Committee, confirming that the effort to secure justice for Puerto Rico is not and should not be a partisan issue. For Puerto Rico to resolve its ultimate status, it must become a state or a sovereign nation, either independent from or in association with the U.S. Territory status should not be an option because it has failed. An enhanced Commonwealth cannot be an option because it is fiction. I have filed legislation that outlines the rights and responsibilities of statehood, provides for an up or down vote in Puerto Rico on the territory's admission as a state, and prescribes the steps the federal government would take if statehood obtains the majority. Those supporting statehood and those opposing it would have equal opportunity to express their views. My bill already has 105 co-sponsors, and it is my hope that a senator will introduce a companion bill. The U.S. citizens of Puerto Rico deserve, and now they have demanded, a democratic and dignified status. Congress must take action. Thank you.
Thank you very much, Commissioner. And let's now go to Senator Berríos. Welcome.
Mr. Chairman, members of the committee, in 1990, the late Senator Patrick Moynihan introduced in the Congressional Record an article of mine published in the Washington Post. The article warned that under territorial status, Puerto Rico would inevitably become either a Commonwealth ghetto or a ghetto state. We're almost there. Puerto Rico is rapidly becoming a Commonwealth ghetto, whereas under statehood, Puerto Rico will become a ghetto state. Last November, 78% of eligible voters participated in a plebiscite in political status in Puerto Rico. Two questions were posed. The first asked voters whether or not they supported the present territorial status. 54% voted no, a solid and undisputable majority. The second question asked whether they preferred independence, statehood, or sovereign free associated state. The result of the second question was neither clear nor irrefutable. Statehood obtained 45% of ballots cast, and 25% in reference to the second question were cast blank. Subsequently, President Obama proposed a $2.5 million appropriation bill for a new status, which could include the already rejected territorial status. Under the guise of inclusiveness, the President of the United States has proposed political subordination as an alternative future status, the same as Senator Murkowski. This is as absurd as offering involuntary servitude or jobs below the minimum wage as remedies for unemployment. International law demands respect for the right of self-determination, and Congress is empowered by the Constitution to dispose of the territory. But international law and constitutional law notwithstanding, Congress will not approve a plebiscite that includes a statehood option, for that would be tantamount to an indirect statehood offer. A statehood option is the death mark of any federally approved plebiscite, simply because Puerto Rican statehood is contrary to U.S. national interest. Before last year's plebiscite, the U.S. consistently argued that Puerto Rico had consented to colonial rule. Since then, maintaining territorial rule, always undemocratic, has mutated into despotism. But the U.S. will only act to decolonize Puerto Rico when it has no other alternative. It is therefore up to us Puerto Ricans to create the political crisis that will compel you to act. If the statehood forces win the next election, they will most probably legislate a statehood yes or no referendum. In another scenario, the present Commonwealth government could convene a constitutional convention to negotiate a non-territorial alternative to the present status. Inevitably, in any case, Congress will soon have to face its responsibility and make real self-determination possible. Such self-determination demands an informed choice between our inalienable right to independence as a distinct and separate nationality and the terms and conditions of any other non-territorial alternative which the U.S. is willing to consider. As to those terms and conditions, you should recall the words of the late Patrick Moynihan on the Senate floor in May 1990. I quote, "In the end, the great issues here presented are civic, not economic. Do Puerto Ricans want to become Americans? Because that is what statehood inevitably means. Or do they wish to preserve a separate identity?" I end quote. Moreover, you must ask yourselves whether you wish the U.S. to continue as a unitary federal state, a pluribus unum, or rather become a multinational state ruled by the motto, a pluribus duo. To conclude, I bring you to attention the case of Oscar López Rivera, a Puerto Rican political prisoner who has languished in U.S. prisons for more than 32 years. 32 years, longer than Nelson Mandela. Puerto Ricans of all political persuasions have demanded his liberation, including the three-party presidents present here today. Surely, a nation that prides itself as a champion of human rights should take the executive decision to liberate Oscar López Rivera. Justice and a sense of decency demand it. I hope the non-presence of President Obama here doesn't mean that he cares so little about Puerto Rico that he's not even willing to consider making an appearance here through one of his representatives or liberate Oscar López Rivera. The three of us demand such liberation.
Thank you all for eloquent presentations. Let me just ask a few questions. I'm going to, in effect, ask them to the panel, and then I know my colleagues are anxious to ask questions as well. In November, a majority of voters opposed continuation of the current territory status. Looking forward to the plebiscite proposed by the President, do you, and we can just go down the row, believe that the Election Commission should agree that the current territory status should not be on the ballot? Let us just go right down the row. We start with you, Governor, and each one of you, if you can answer yes or no, that would be helpful.
Okay. Thank you, Chairman. First, Commonwealth wasn't there. Commonwealth cannot be defined as the current territorial status. That's a mistake. Call the Commonwealth a territorial is a question of law. Being a question of law, I want to state in this committee a word of a sitting judge of the United States of America, Mr. Justice Breyer, when he was in the First Circuit. The case is Cordova versus Chase. And I quote, in sum, Puerto Rico's status changed from that of a mere territory.
Governor, I want to be respectful, but my time is going to go by very quickly and I have other questions. Do you believe that the Election Commission should agree that the current territory status should not be on the ballot?
It's a mistake to call Commonwealth the current territorial status. The Commonwealth wasn't there. The Commonwealth wasn't there. Imagine, Senator, and that's why it's only a paragraph. And the federal government relation with Puerto Rico changed from being bounded merely by the territorial clause and the right of the people of Puerto Rico as United States citizens to being bounded, listen carefully, to being bounded by the United States and Puerto Rico Constitution, Public Law 600, the Puerto Rico Federal Relation Act, and the rights of the people of Puerto Rico as U.S. citizens. I cannot call the United States of America the Empire of the West because it's a mistake. I cannot place in a ballot Commonwealth independence and federal taxes and losing Olympic Committee and losing our national identity because that's not the name of statehood. Commonwealth have and needs to be.
Governor, again, my time is going to run out even before we get through one question. I think what you're telling me is you want another option on the ballot. And
no, Commonwealth needs to be there. And as Felix Frankfurter says, address the issue of a non-state jurisdiction of the United States is an issue of statesmanship, creative statesmanship. And
but we're just going to have to move on. Let's see. Let's now go to the Commissioner. Commissioner, do you believe that the Election Commission should agree that the current territory status should not be on the ballot?
I take it you're basing the question on the pending appropriation request from the President, which calls for a process to, I quote, solve Puerto Rico's status. You cannot solve the problem of our status by including the very option that was rejected by our people. Elections, as well as plebiscites, have consequences. The people were asked, very simply, do you want Puerto Rico to continue having its current status? And they said resoundingly no. So the options should be statehood, free association, and independence, the three alternatives we have to the current status.
Senator, same question. Do you believe the Election Commission should agree that the current territory status should not be on the ballot?
Well, of course not. First, because...
You said no. Oh, my goodness, I got an answer.
Oh,
Thank you.
I'm very straightforward.
You are indeed.
I'm for independence.
Thank you. Very good. All right. Would you like
to
amplify on that? I want to be
enough?
serious. I want to be respectful. Would you like to amplify on your no answer?
No, we already said no. And to ask us again would be as absurd as asking them to accept involuntary servitude already rejected by the Puerto Rican people. It's absurd.
All right. Let me see if I can get one other question in with respect to translating this issue of free association. One of the choices on the November ballot was sovereign free association. In English, this phrase would be taken to mean the current free association relationship between the U.S. and the three nations of the former U.S.-administered trust territory of the Pacific. However, some are concerned that when this phrase is expressed in Spanish, voters may confuse it with the Spanish phrase for the current Commonwealth or the proposed enhanced Commonwealth. So my question here is for each of you gentlemen. Do you think that this concern about confusion through translation is a valid one?
Yes.
Very good. Your colleagues.
No, I do not believe that that creates much confusion. In Puerto Rico, our voters are well educated about the options we have.
Senator.
We have debated this topic long enough.
Very
That phrase was invented by Puerto Rican colonialists in 1952. They call it Commonwealth here, so it will pass as a Commonwealth of Pennsylvania or Massachusetts, and they call it free associated state there in order to confuse the people thinking it was some sort of a sovereign association. But now, 60 years later, obviously nobody's going to be confused by that.
So people are not going to be confused in your view. Very good. Senator Murkowski.
Well, since we're talking about definitions here and whether or not they cause some confusion, Governor, can you define exactly what enhanced Commonwealth really means? Because I'm not sure that I understand it.
Thank you, Senator, for that question. I think it's a very valid one. A good example of serious consideration by Congress of the enhanced development of Commonwealth may be found in the legislative process between 89 and 91. And during the 1975 ad hoc procedure. But in 1975, a young fellow of the Department of Justice quotes in a letter, "The proposed compact would, without altering the fundamental nature of Puerto Rico's Commonwealth status, provide substantially increased autonomy to the island's government and its people." And we can talk about, for example, that those processes that have been already studied by Congress and by the Commonwealth to see what federal laws apply to Puerto Rico that cannot damage the possibility of economic development of Puerto Rico, or the language in federal courts in Puerto Rico that should be Spanish. That young fellow, the name of that young fellow back in 1975, Mitchell McConnell Jr., minority leader in the Senate.
Governor, what I'm trying to understand is exactly what enhanced Commonwealth is, and because the question really here is whether or not it's consistent with the U.S. Constitution. Now, I understand that your legislature has passed this resolution that when we're talking about the plebiscite, it says incorporates all options, including the enhanced Commonwealth. But if our Department of Justice should determine that enhanced Commonwealth does not, in fact, meet with the definitions within our U.S. Constitution, doesn't fit within that, we've got a situation here where you're going to have a plebiscite that again, is not going to be followed or upheld. So what I'm trying to understand is how we're defining this, and is it consistent with our Constitution?
Again,
because we recognize that there is a challenge there.
Great question, but it's something, as all of us know, who evaluate the constitutionality of something is the Supreme Court, and the Supreme Court already resolved this issue. Let's see U.S. versus Lara, the same judge, Mr. Justice Breyer. Third, Congress' statutory goal to modify the degree of autonomy enjoyed by the dependent sovereign that is not a state is not unusual legislative objective. The political branches drawing upon analogous constitutional authority have made adjustments to the autonomous status of other such dependent entities, sometimes making far more radical adjustments than those at issue here. That's a Supreme Court decision. You can, of course it's constitutional, And the Supreme Court has stated that every time that have been asked.
I would suggest that there is still an issue there in terms of the constitutionality, and this is part of what we're dealing with and trying to understand here. Let me ask you a question here, Commissioner Pierluisi. I mentioned in my opening statement that when Alaska was seeking statehood, it was Alaskans engaged, very, very engaged in pushing towards statehood. In fact, at the time that the case was successfully made, it was about over 80% of the Alaskan electorate supported that, an overwhelming majority. Do you think that Congress should consider a statehood petition if the status does not have a majority, let alone a supermajority of the voters?
Well, let me answer it this way. We are driving the process the same way Alaska did back in the 50s. Different times, though. This is the 21st century. But we're driving the process. We just held a vote in Puerto Rico. And as I said, plebiscites as elections have consequences. The people rejected the current status. And this is the most democratic nation in the world, and you cannot ignore that vote. You need to respond to that vote. One way of responding is the way that I am proposing in the House, H.R. 2000. It basically lays out statehood for the voters of Puerto Rico and asks for an up or down vote on the admission of Puerto Rico as a state, and then provides the steps that the federal government would take to admit Puerto Rico as a state if that's the wish of the majority of the people of Puerto Rico. But that's driven by Puerto Rico because I represent Puerto Rico in Congress. Now, by the way, you asked a question, and if you allow me, let me quickly answer. What the PDP has been proposing for a long time now is that the relationship between Puerto Rico and the U.S. be based on a compact or treaty that cannot be changed by either party, must be changed by mutual agreement. That, in and of itself, is unconstitutional. In addition, what they're proposing is that Puerto Rico would keep the same level of federal funding, yet have the ability to decide which federal laws apply in Puerto Rico and which do not. I am sure that many colleagues representing the states would like to have that power as well. That's why, consistently, among other reasons, the federal government, DOJ, as well as this committee and the counterpart committee in the House have said that such proposal is unconstitutional. It violates public policy. The name doesn't change the nature of the status. Puerto Rico is, as a matter of law, an unincorporated territory of the United States. It is called the Commonwealth because the Constitution of Puerto Rico, which was approved by the U.S. Congress, calls the government of Puerto Rico the Commonwealth of Puerto Rico. So I try to be brief, but I believe that answers your question. They're proposing an unconstitutional relationship with the U.S., and that's why it cannot be on the ballot. But the current status, call it as you may, Commonwealth, unincorporated territory, Puerto Rico, call it whatever, was rejected by the people of Puerto Rico. And we've waited long enough. We want Congress to take action.
Mr. Chairman, my time has expired.
Senator Heinrich.
Thank you, Mr. Chairman. I want to ask Governor Garcia Padilla, under what you're calling an enhanced Commonwealth, would Puerto Rico be subject to all the federal laws that the Congress, House, and Senate, signed by the President, are passed, or would you pick and choose which laws?
No one is trying to mislead you if anyone tells you that we want to pick. What have been studied in 1975 process with approval of the Department of Justice, what was stated to Congress in 1989 to 91 process and passed the House unanimously was a process between Congress and Puerto Rico. And both will agree if there's any federal law that can damage in a different way without damaging the effect of that law in the states, damage the possibility of the economy of Puerto Rico to move on. So it's the process between the Congress and the people of Puerto Rico, not a picking process.
So, Governor, what exactly is an enhanced Commonwealth?
Let's go, for example, it has been studied very well. And as I told you, passed the House already once and stayed here in the Senate. We can arrange that a way where federal laws will apply to Puerto Rico, but in a mutual working together with Congress, not Puerto Rico alone. We can talk about federal courts in Puerto Rico, not about the application of the federal courts to Puerto Rico, but the language there. The federal courts in Puerto Rico is struggling with the language in Puerto Rico because most of Puerto Ricans speak Spanish. And there you have two examples. But let me tell you something, Senator. To take Commonwealth out of the ballot is...
Well, I think we've already established...
No, but I didn't answer that.
I mean, there's a very clear question on the ballot in November. And people made a decision, and I think we have to respect that decision.
I know, but the Commonwealth wasn't there.
That's
disenfranchisement.
Well,
that's
I would submit that there are 4 constitutionally valid options here: Commonwealth, independent, statehood, and free association.
I agree.
And in my reading of this ballot, it's fairly clear that the voters rejected Commonwealth status.
Commonwealth was there, Senator?
That gives us 3 remaining choices. And I think, you know, we've sort of danced semantically around this for long enough that we have to move forward and begin to make some decisions here. I want to move on to Commissioner Pierluisi. If you've introduced a bill in the House, I understand, that would just hold a straight up or down vote on statehood. If what people are saying about the intent of voters who left their ballots blank, that's a fairly risky proposition. But obviously, you believe that that's the best way to get a very clear idea of how people feel on statehood. Say that vote comes out favorably to what you want to see, and the voters in Puerto Rico vote yes. What would walk us through the next steps? Because obviously that doesn't result immediately in statehood. Of all the steps we'd have to walk through to actually see that come to fruition and see Puerto Rico become a state.
The bill provides that the president shall submit an admission, a bill admitting Puerto Rico as a state within the period of 180 days. The bill should include a transition period during which additional federal monies would flow into Puerto Rico and federal contributions would be gradually applied. The Congress, the bill then provides that Congress is committed to act on the legislation and so admit Puerto Rico. The bill, as it says in its first sentence, sets forth the process for admitting Puerto Rico as a state of the Union. So it is an admission bill, and it provides that process that I just laid out for you.
Thank you, Chairman.
Thank you very much.
Mr. Chairman?
Yes, indeed.
I would like to add a couple of points.
Please.
Since they've had plenty of time.
Please.
Mr. Chairman, nobody knows what enhanced Commonwealth means. They've been trying to define it for half a century. Nobody knows. So the answer is nobody knows. This is just juridical hocus pocus, juridical bull, to put it in plain English. So you shouldn't stress the point anymore because they won't define it. In definition is their name for the territory. And the territory has been repudiated by 54% of the Puerto Rican people. Now it has transmuted itself into tyranny. So it seems to me here, since you want information to take positive steps ahead, we're in the middle of a discussion similar to those held in the Middle Ages where people ask how many angels fit into a needle's head. You won't approve anything that says even indirectly you will accept statehood. So as long as statehood is in his bill or your bill, nothing will happen. And as long as Commonwealth remains, we remain a colony, a territory. It's about time you start speaking frankly to the Puerto Rican people, telling them what are the conditions under which you would accept, if you could accept statehood, refuse to consider colonialism any longer, and make a reasonable offer between our inalienable right to govern ourselves, either under independence or on any other formula of a non-territorial nature. If it's statehood, state the conditions for statehood. If it's free association, state the conditions for free association. That's the way to go. If not, we're losing our time once more in this Senate, the Senate's time and our time.
Recognizing the perils of asking for a yes or no answer, I'm going to try once more on an issue that I do think that there's some common ground, and I hope that there is. Governor, we'll start with you. Should the ballot question under the president's proposal be simplified to statehood, yes or no, or sovereignty, yes or no?
No, I want to tell you why. First, take Commonwealth out of the ballot is a way to disenfranchise the majority of the people of Puerto Rico that have voted for the Commonwealth every time the Commonwealth have been in the ballot. This time, Commonwealth wasn't there. Second, I'm not pro-independence, as you know. But I have to protect the right of the pro-independence people to have their option in the ballot.
Thank you.
You're welcome. And I'm not pro-statehood. That will make Puerto Rico a Latino ghetto. And I have to defend the pro-statehooders to have their option in the ballot. I cannot disenfranchise them. It's not payback time for me because I was disenfranchised in November. And what the pro-statehood party is asking you, Chairman, and this committee, is to be accomplice of that democratic crime against democracy. Take the one who won. Always the people have been asked out of the ballot because if the Commonwealth is in the ballot, they have no way to win.
Governor, the reason that I asked the question was leaders in your party have endorsed statehood, yes or no, for this committee in 2010 and in hearings before the House Resources Committee in 2009, and that's why it's relevant. Let me get,
let me add
your colleagues.
No, but let me add something, Senator. People in pro-statehood party have expressed that they are not agree with the yes or no for statehood process. So that's a democracy.
What your leaders in the past endorsed was framing the issue statehood, yes or no, and that's a matter of public record. So let me just get your colleagues into this, and let me have the other senators ask any remaining questions.
I'll be brief. By definition, when you pose a question as a yes or no question, you're not excluding anybody, because whoever is in support of the proposition can vote yes, and whoever is against can vote no. So it's to talk about excluding anybody when you're posing an up or down question, it's just nonsensical. Now, whether we can use the $2.5 million for consulting the people of Puerto Rico on the potential admission of Puerto Rico as a state, of course we can. It is consistent with the language of the appropriation because it is directed to resolving the issue of Puerto Rico status, and definitely one of the options through which you can solve this problem is by admitting Puerto Rico as a state. The other option, I do not support because there's no support for majority support. You cannot even argue there's anything close to it for Puerto Rico becoming a national, treated as a sovereign nation. But again, I would say that if somebody proposes that vote, what's going to happen is that the overwhelming majority of Puerto Ricans will vote against. So I wouldn't say that I'm being excluded as a statehooder. I would simply vote no if the question is the second one that you posed.
Senator?
Well, statehood, yes or no,
or sovereignty, yes or no? The question.
No, you need to push.
Excuse me. Statehood first. A statehood yes or no referendum stemming from this Congress is an impossible proposition. You will never get passed through even this committee. I can assure you that through 30 years of experience. The United States will never make such an offer. So that's out of the question. Now, regarding the second question, we have an inalienable right to independence under international law. if you are willing to make a statement publicly and push through a status referendum where you offer independence with a reasonable transition, as it should be for your benefit and for our benefit, of course I would accept independence, yes or no referendum.
Let's do this. I'm going to let my colleagues ask any additional questions and then give my assessment of where we are at this point. I will tell you I thought it was particularly noteworthy, given some of the history, Senator Murkowski, in fact, the current Senator Murkowski, knows a little bit about this because in 2001, the U.S. Department of Justice wrote to the former chairman of this committee, who was Senator Murkowski's father, Frank Murkowski, with the finding that enhanced Commonwealth is inconsistent with the Constitution. So this debate's been running a little while.
Long while.
Senator Murkowski, the current Senator Murkowski.
Let me ask you a question, Senator Berrios, because you brought up the issue of self-determination, yes, the right of all peoples to self-determination. But then in response to another colleague here, you indicated that, look, we here in Congress should just set out these conditions. You've said territorial status is out, it should be dropped, that the option for statehood is unrealistic. But if we were to basically provide these conditions to you, isn't that just another form of Washington, D.C. dictating to Puerto Rico whether it's the level of status or the conditions? How does that address this right of self-determination that you've spoken of?
Senator Murkowski, when you came into Puerto Rico in 1898, you asked nobody. You just invaded. I don't mean you. You were a territory.
Thank you.
The United States invaded Puerto Rico and consulted nobody. Under the law, international law, you should devolve our powers so we can exercise our free determination. That is not going to happen, of course. You will only do that when you have no other option. We accept that statehood be put in a plebiscite in the future after the United States, if it's through a congressional, if the United States is willing to spell out the conditions for statehood.
And you don't think that that's then dictating in violation of your
No, because
right to self-determination?
Because the only right you have as a nation, not as Alaskans, nor as Hawaiians, nor as Texans, as a nation, the only right is a right to independence juridically. We know we are not the majority in Puerto Rico. What we say is that if a referendum is going to be held through an act of Congress, independence has to be included with a transitional period which should be included in independence. And if any other option is going to be included through an act of Congress, free association or statehood, then you should spell out whether you are willing to grant that once it is approved. Because once independence wins a referendum, there's no option. You have to act upon a petition for independence. We're in the 21st century, not in 1898. That's what I mean.
Could I comment? I'm going to try to be brief. The same way you cannot impose statehood on Puerto Rico. We, the American citizens of Puerto Rico, cannot impose statehood on you. Definitely, you can lay out the terms and conditions for statehood. But by the way, we're not seeking a special statehood for Puerto Rico. It would be statehood on equal footing with the 50 other states. The only terms and conditions that you would be laying out would be, for example, the transition period, because this doesn't have to happen overnight. You can provide for a 6-year transition period, 8-year transition period, in which you would gradually give us parity. We don't have parity, equal treatment in federal programs. At the same time, you would gradually impose federal taxes on the island, income taxes. So that's the only aspect that under which we could have a different treatment than the states, and it would only last during the transition period. But of course, it's like for a change of status to happen, two things must happen. Congress must provide for it, and the people of Puerto Rico must accept it. So you cannot detract yourself from the process. You have to be engaged. And we're driving the process in the sense that we already held a plebiscite. We can, very much so, morally and legally do it. And we're telling you, act on it, respond to it.
Senator, if you permit me for a moment.
Senator.
There's one condition for statehood, which the Resident Commission hasn't mentioned. It's Senator Moynihan's questions. Do Puerto Ricans know they have to become Americans in order to become a state of the Union? Or do they want their own separate identity? That's beyond economic transition. It deals with the way of being, the nature of being Puerto Rican. That's called a nationality under international law. We are a distinct nationality. Do we want to continue as a distinct nationality? Congress should be clear. Like Senator Moynihan, who was an expert on these matters. If you want to become a state of the Union, you have to become Americans. You cannot maintain your separate identity in the long run. That's a condition also which should be spelled out.
Mm-hmm.
Senator Heinrich.
Senator Berríos, following up on that idea, what would you think of a ballot that first asks up front, you know, should Puerto Rico be part of the United States? Yes or no?
Well,
and if the answer is yes, then you choose on the second tier between statehood and the current status, Commonwealth status.
Of course not, because you cannot exclude independence in any
But
valid plebiscite.
if they say no,
No, but you can.
then you go and you choose
No,
between
but this,
independence and free
this
association.
being part of the United States or not doesn't include independence. Independence means independence. It
Right.
has
No,
to be-
no, I recognize that. I agree with you. But if the people of Puerto Rico vote no, we should not be part of the United States, then
No.
then you
That's not being part of the United States. It's independence. It's a positive, like the United States. You are independent. You have a right as a nation to be independent. We are a colony of the United States. What you can ask us is whether we want to become independent or not. That you can ask. Not whether we want to be part of the United States. Of course, we don't want to be part of the United States as a colony. The stateholders don't want it. Neither do we want it.
Commissioner, do you have an opinion on that?
Well, my reaction is that if you pose a question like that, probably 80 to 90% of the people will say that they want Puerto Rico to continue to be part of the United States. Actually, legally, if we go by the Supreme Court precedent, it's not technically part. It's just
Belongs to.
It belongs to. It is a possession or territory of the United States. But the answer would be overwhelming. The same way, as I said before, if you pose the question, national sovereignty, yes or no, I'm telling you, the overwhelming majority are going to go vote against national sovereignty. And to react to something that Senator Berríos just told you, we are proud American citizens. I know, I respect my fellow independentistas, from Puerto Rico. I do respect them and their ideal, but, we're proud American citizens. If you poll in Puerto Rico whether people want to continue having their American citizenship, it's going to be like 80 or 90% again. So votes should be meaningful. Mm-hmm. That question to me is not meaningful because we already know the answer to it.
Senator. Of course, we respect independentistas. Everybody in the world does, The question is whether the world respects estadistas or Commonwealthers. Of course. And I'm very glad that after 60 years of persecution of the independence forces, now we have the right to speak, this is all, we'll blabber on. Nothing is going to happen here. Nothing is. You will not act. I repeat, don't fool yourself. You will not act as long as statehood is a possibility offered. You will not act. But you have to act to decolonize. Think about it. How do you do it? How do you decolonize without including statehood as one of the alternatives? Senator Pierluisi's resident commissioner's bill will go nowhere. These readings, we're grateful, but they'll go nowhere either.
Governor, you wanted to add something?
Yes, Senator, thank you. Precisely on the White House Task Force report, they suggest the idea of a two-question referendum on if we want to remain part of the United States being the Commonwealth and the statehood, the alternative, and if not, independence or sovereign, being not part. The two options that win will go to a second question. And we endorse that. But let me tell you, let me go further. To exclude, let's say, for the sake of argument, that Commonwealth and what they call current territorial status is the same, and we have to exclude that. Statehood lost in 93, in 98, in 67, and we are not proposing to exclude statehood because they lose. Exclude the Commonwealth from the ballot is disenfranchisement. That's why I in favor of including all the formulas, or the ballot formulas, or the ballot options in the ballot. And I think that fairness. The majority of the people of Puerto Rico have been voting for Commonwealth every time the Commonwealth is in the ballot. And now they want to take it, disenfranchise the majority of Puerto Rico. I know that you, Senator, not the chairman, not Senator Markowski, will talk Plessy. And that will be talking Plessy.
Talking what?
Plessy versus Ferguson.
Let me give you my assessment of where we are. First, gentlemen, you should know that this committee's made a special focus on trying to resolve issues that I usually characterize as running longer than the Trojan War. They just kind of go on and on and on, and we've had some success in a number of areas. A few weeks ago, there was a report in one of the newspapers that we had sent more bills to the floor of the United States Senate than all the other committees together. So that's because we try to find common ground. We are going to need your leadership here in order to do that. And let me give you my take in terms of where we are. I think we've made some progress. 2 out of 3 of you seem to believe that the current status and enhanced Commonwealth are no longer options. They're no longer options on the table. 2 out of 3 of you. So looking forward, it seems to me that it's especially important to see if the 3 of you can come to an agreement on the language of a ballot that, in effect, has 2 remaining options: statehood or sovereignty as an independent, freely associated state. And absent an agreement of the 3 of you, it seems that this will just go round and round some more. So we very much look forward to working with you. I'm sure that the people of Puerto Rico want this, resolved, and we are interested in working constructively and closely with you. So unless Senator Murkowski wants to add anything else, or Senator Heinrich, we'll just let Senator Murkowski's going to have the last word.
Well, I don't mean to have the last word,
sure.
but I wanted to share with you a thought that I just shared with the chairman here in reflecting on Alaska's statehood fight. It was a 90-plus year fight, and I'm reminded that it took us 90 years to get to statehood, and for us, the only decision was up or down on statehood. And the fact that Puerto Rico has been engaged in this issue for also many, many decades, but the fact that you have as many options as you do makes it perhaps even more difficult than Alaska faced when it was just an up or down. And as I would agree with the chairman, that the process for determining what the options will be on the ballot and how they are defined is as critical as anything that we have discussed here today. So it's a challenge to you and those that you represent to try to address how we define what the options are and then how they would therefore be defined on this ballot moving forward. So I thank the chairman and certainly thank you gentlemen for leading the discussion here this morning.
Gentlemen, thank you. As you can see, the senators here, both political parties, want to work closely with you and get this resolved. And with that, the Energy Committee is adjourned.
Mr. Chairman,